Hello my friends, I Forum Patel would like to welcome you all to the last session on the trade unions under the labor laws. Now, in the previous sessions my friends, we discussed about the whole concept, the overall idea about the Trade Unions Act, including important definitions, objectives, registration process and dissolution process of the trade unions. After that, we discussed about the collective bargaining process and industrial relationship at large. After that, we have to discuss the classifications of the trade unions. So friends, let's get started with the understanding of the classifications of the trade union. As you can see on the screen, I have kept 3 different columns for the classification of the trade unions. The first one talks about the representative, the second one about the qualified, and the third one about the primary. Now, what are these kinds or what are these classifications? Representative classification, my friends, it means a union for the time being registered as a representative union. Qualified, of course, time being in force registered as a qualified, and primary, of course, as a primary. Under the representative trade union, my friends, the union should be able to muster 15% of the total numbers of the employees employed in any industry in a contingent area. Under the qualified industries, under the qualified trade unions classification, my friends, the union should have 5% of the employees in the industry enrolled as the members. If no union in the local area is qualified for the representative union, they will be falling under the criteria or under the classification of the qualified trade unions. Now, when we are talking about the primary trade union, this union should have 15% or more employees or plant of that area of the industry. So that means, my friends, that the classification of the trade union has been done under the Bombay Industrial Relationship Act 1946. It is the first state legislation providing this recognition. Prior to 1946, there was no provision in the law with regard to the recognition of any of these trade unions. This act is only applicable to certain industries like silk, cotton, hosiery, woolen, textile, banking, or sugar, or cooperative natures, etc. etc. This act provides this classification on the basis as discussed before. So my friends, if you are putting the whole concept in a very nutshell manner, you can state that the representative and qualified unions, they are the unions of in respect of the whole industry in a local area. Primary union is in respect of the particular undertaking in the area of that industry. In the court of law, the representative union has the first preference to appear than any other union because, of course, of its nature. Now, it represents all its members, even if all its representative, rather, it includes all the employees, not only the members, and that is the reason in the court of law the representative union has a better standing than of the qualified or the primary trade union, my friends. So this was all about the classification of the trade unions at glance. Till now, we discussed about the Trade Unions Act, its objective, the history of the trade union, concept of trade unionism, definitions, registration process, amalgamation process, dissolution process, then collective bargaining and industrial relationship, along with the classification of the trade union. Now, in this unit, we have covered all these things. In the next video session, we shall be starting to discuss about the Industrial Employment Standing Orders Act 1946, my friends. Till then, you guys stay tuned and keep learning. Thank you so much.